Good afternoon, everyone. Good afternoon to our active Professor Dr. Juvenal Laktam, sir. Have a nice afternoon. By the way, I am Roselyn Tanoy from Patawag National High School, Liloy 1 District, Schools Division of Zamboanga del Norte. My report is about teachers and professors as person in authority. So let's define first what is a teacher. A teacher is a person who provides education for students, who helps others learn new things. What is authority? The power or right to give orders, make decisions, and enforce obedience. A person having power or control in a particular, typically political or administrative sphere. The power to influence others, especially because of one's commanding manner or one's recognized knowledge about something. Due to the fact that the teacher is in the role of the manager of the class, they require power in another form, the authority to influence student behavior. This could be termed teacher authority. Teacher authority is in a sense the right to ask others to do something. As teachers, we need to ask students to do many things in a day, and we need to make a request out of some basis of authority. Without it, we would have little efficacy. French and Rabin 1974, as they examined classroom interactions, identified 5 basic forms of teacher authority. Each needs to operate to some degree, but some will be emphasized and utilized more than the others for most of us. These 5 types are attractive or referent, expert, reward, coercive, and position are legitimate. So as you can see in the chart, these are the 5 types of authority. So what is attractive or referent authority? When the teacher relies on their personality, relationship building, or the fact that they share common interests with students, they could be said to be using attractive authority. Attractive authority can be developed through getting to know and emotionally investing in students. In a sense, when the teacher makes deposits in what calls the emotional bank account of the students, they can use their withdrawals as opportunities to influence behavior. The use of attractive authority to influence student behavior can be both effective as well as healthy. It is difficult to be effective without some degree of it. As the saying goes, students do not care how much you know until they know how much you care. Students work harder for teachers they like and perceive as caring. However, pandering for student approval and letting the need to be liked drive one's teaching choices will lead to many problems. If the teacher confuses relationship building for an implicit bargain with the students that I will be nice to you if you are nice to me, then this can be a slippery slope that leads to giving away one's power and being taken advantage of. Next is expert authority. When the teacher is perceived as being knowledgeable in the subject, well prepared or intelligent, they possess what could be called expert authority. Expert authority is driven by the student's desire to know. Some of this form of power comes from a natural human deference for those who are perceived as wise or possess what could be called intellectual capital. The use of expert authority to lead can be effective. It can translate into respect if the teacher is not arrogant or entirely imperceptive of the needs of his or her students. Humor can be a great asset for the teacher who chooses to rely heavily on this form of authority, but to exclusively trust expert authority as being sufficient has been the downfall of a countless number of teachers. Many teachers enter the profession with a passion for this subject and leave 1 year later when their passion is met by a disappointingly high degree of disinterest and disrespect. Reward authority. What is reward authority? So teachers have the ability to give rewards to the students, no, for this include achievements, no, as what I understand in my teaching experiences. So reward is part of the achievements, encouragement of the students to participate in the class. So this includes grades, recognition, prizes, praise, privileges, and anything else that could be assumed that students desire that could be given to them externally by the teacher. The notion of rewarding student behavior can be potentially effective, but as we'll explore, there are vastly different effects from different kinds of rewards. So next one is coercive authority. The teacher has in their power the right to use these incentives to say no, withhold privileges, and give consequences or punishments to students. When they do this, we could say that they are exercising their coercive authority. Coercive authority implies that if a line is crossed, something will happen that will be less desirable for your student. No matter how much of the other forms of authority a teacher possesses, without some amount of coercive authority, it is likely that some students will take advantage of their freedom to cross lines without concern for boundaries. Used constructively, this form of authority is important to draw lines and boundaries. It helps promote a sense of security in the class for those students who are not inclined to cross lines and count on the teacher to take action with those who are so inclined. So the last one is possession or legitimate authority. By virtue of the fact that the teacher is the possession of the teacher, they have authority. The governance of the school places each teacher in a position of responsibility for the management of the students in the class. So in one sense, it is not so much earned as it just exists. Likewise, in the role of teacher is the assumption of have authority. There is no other person in the classroom that can fulfill the duties of the teacher. We could use the term in loco parentes to describe this type of power. The teacher, in addition to the role as educator, is the sanctioned authority in the room. Unlike the other forms of teacher authority, possession authority is not so much earned or cultivated. It exists by default. Nevertheless, we can do a better or worse job of projecting or meriting this role. This is especially true of new and of substitute teachers. Those who expect to be given respect usually are. While possession authority may come essentially from a contract, it is also projected in an air of legitimacy and confidence. Those who project an effect characterized by legitimacy or a doubt that they belong in the position will suffer from a limited amount of possession authority and the problems that come with it. Who are teachers? The Magna Carta for Public School Teachers, Republic Act Number 4670, June 18, 1966, Section 2, Teachers, and shall apply to all public school teachers except those in the professorial staff of state colleges and universities. As used in this act, the term teacher shall mean all persons engaged in classroom teaching in any level of instruction on full-time basis, including guidance counselors, school librarians, industrial arts, or vocational instructors, and all other persons performing supervisory and or administrative functions in all schools, colleges, and universities operated by the government or its political subdivisions, but shall not include school nurses, school physicians, school dentists, and other school employees. Presidential Decree Number 1006, promulgated on September 22, 1976, and made effective on January 1, 1972. According to this decree, teaching refers to the profession primarily concerned with a classroom at elementary and secondary levels in both public and private schools. The term teacher refers to all persons engaged in teaching, including guidance counselor, school librarians, industrial, arts, or vocational teachers, and all other persons performing supervisory and administrative functions. A professional teacher is one who has a permanent appointment under the Magna Carta for public school teachers and all others who may qualify for registration. Who is a person in authority? Batas Pambansa Bilang 232, Education Act of 1982, September 11, 1982. Section 11, Part 3. Teachers shall be deemed persons in authority when in the discharge of lawful duties and responsibilities and shall therefore be accorded due respect and protection. Commonwealth Act Number 578, June 8, 1940, Commonwealth Act Number 578, an act to amend Article 152 of the revised Penal Code so as to include teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities within the term person in authority. Section 1, Article 152 of Act Number 3850, known as the Revised Penal Code, is amended to read as follows. Article 152, persons in authority who shall be deemed as such in applying the provisions of the preceding and other articles of this code in any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission, shall be deemed a person in authority. In applying the provisions of Articles 148 and 151 of this code, teachers, professors, and persons charged with supervision of public or duly recognized private schools, colleges, and universities shall be deemed persons in authority. Section 2, this act shall take effect upon its approval, enacted without executive approval, June 8, 1940. Batas Pambansa Bilang 873, June 1985, an act amending Article 152 of the revised Penal Code by considering lawyers as persons in authority when in the performance of their duties or on the occasion thereof. Section 1, Article 152 of the Revised Penal Code is amended as follows. Person in authority and agents of person is authority who shall be deemed as such in applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed as person in authority. Any person who by direct provision of law or by election or by appointment by competent authority is charged with the maintenance of public order and the protection and security of life and property, such as barrio councilman, barrio policeman, and barangay leader, and any person who comes to the aid of persons in authority shall be deemed an agent of a person in authority. In applying the provisions of Articles 148 and 151 of this code, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities, and lawyers in the actual performance of their professional duties on the occasion of such performance shall be deemed persons in authority. Section 2, approval. This amendment shall take effect 30 days after its publication in the official gazette, approved June 12, 1985. Liability. What is liability? So what are those liabilities? Book 2, Civil Code Obligations and Contracts, quasi-delects. Article 2176, whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence is obliged to pay for the damage if there is no pre-existing contractual relation between the parties is called a quasi-delict. is governed by the provisions. Article 2180, the obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those or person for whom one is responsible. The father, and in case the death of the father is the mother, are responsible of the family. Guardians are liable for the damages caused by the minors or incapacitated persons who are under their authority and live in their company, so in the absence of the mother and the father. The owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of their functions. Employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The state is responsible in like manner when it acts through a special agent, but not when the damage has been caused by the official to whom the task done properly pertains, in which case was what is provided in Article 2176 shall be applicable. Lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices so long as they remain in their custody. The responsibility treated of in this article shall cease when the persons herein mentioned prove that they observed all the diligence of a good father of a family to prevent damage. Family Code of the Philippines, Article 218. The school, its administrators and teachers, or the individual entity or institution engaged in child care shall have special parental authority and responsibility over the minor child while under their supervision, instruction, or custody. Authority and responsibility shall apply to all authorized activities, whether inside or outside the premises of the school, entity, or institution. Article 219. Those given the authority and responsibility under the preceding article shall be principally and solidarily liable for damages caused by the acts or omissions of the emancipated minor, the parents, judicial guardians, or the persons exercising substitute parental authority over said minor shall be subsidiarily liable. The respective liabilities of those referred to in the preceding paragraph shall not apply if it is proved that they exercised the proper diligence required under the particular circumstances. Some related decided cases. Attacking a teacher who had inflicted corporal punishment on a pupil is direct assault. A corporal punishment, for instance, slightly slapping, inflicted by the offended party upon her pupil, does not in any way strip the teacher of her being a person in authority. A teacher in public elementary school has authority to inflict corporal punishment on a pupil if no bodily harm is caused and the punishment inflicted is moderate, is not dictated by any bad motive, is such as usual in school and such as the parent of the child might expect that the child would receive if he did wrong. Such authority, which is inherent to the position of a teacher, especially in grade schools, is complement of the old adage, spare the rod and spoil the child. Reasons why teachers and professors are protected in Articles 148 and 151. The spirit and purpose behind Commonwealth Act number 578 is to give teachers protection, dignity, and respect while in the performance of their official duties. This protection extends not only against pupils or relatives of pupils, but against all persons who knowingly attack a teacher while engaged in the performance of his official duties. Respect for a teacher is required of all persons, whether pupils or otherwise, if we are to uphold and enhance the dignity of the teaching profession, which the law similarly enjoins upon all persons for the sake of the pupils and the profession itself. So, for example, ex conde versus Capuno. So the facts, Dante Capuno was a 15-year-old boy who was a pupil of Balintawak Elementary School. In March 1949, he attended a Boy Scout parade for Dr. Jose Rizal. While they were inside a jeep, he took control of the wheels, which he later lost control of, causing the jeep to go turtle, thereby killing other students, Isidoro Capirina and one other. Isidoro's mother sued Dandy Capuno for the death of her son. Pending the criminal action, the mother reserved her right to file a separate civil action, which she subsequently filed against Dante and his dad, Delphine Capuno. Issue: whether or not Delphine Capuno, as the father of Dante, is liable for damages. Held, yes, the civil liability which the law imposes upon the father, and in case of his death or incapacity, the matter for any damages that caused by the minor children who live with them is obvious. This is necessary consequence of the parental authority they exercise over them, which imposes upon the parents the duty of supporting them in proportion to their means, while on the other hand, gives them the right to correct and punish them in moderation. The only way by which they can relieve themselves of this liability is if they prove that they exercised all the diligence of a good father of a family to prevent the damage which Delphine failed to prove. On the other hand, the school is not liable. It is true that under the law, teachers or directors of arts and trades are liable for any damages caused by their pupils or apprentices while they are under their custody, but this provision only applies to an institution of arts and trades and not to any academic educational institution. The legal basis of teachers as person in authority. So let's find out what are those legal bases. So definition of persons in authority under the revised penal code of the Philippines. It is directly vested with jurisdiction whether as an individual or a member of some court or government corporation, board, or commission. In essence, teachers are not person in authority since they are not directly vested with jurisdiction or power to govern and execute laws, but by legal fiction because of the provisions of Commonwealth Act 578 duly amended by Article 152 of the revised penal code, teachers became persons in authority. So it's because of the Commonwealth Act 578. By the phrase directly vested with jurisdiction is meant the power or authority to govern and execute laws, particularly the authority vested in the judges to administer judges. That is try civil or criminal cases or both and to render judgment in accordance with laws. The term persons in authority according to court decisions also include municipal mayor, provincial fiscals, municipal councilors, and barangay chairman. Persons in authority distinguished from agents or person in authority. Persons in authority should not be taken to mean as agents of a person in authority. This is because an agent of a person in authority is one who, by direct provision of law or by election or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property, such as barrio policeman and any person who comes to the aid of persons in authority. No? The following consider as agents of persons in authority: policeman, municipal treasurer, postmaster, rural policeman, sheriff, agent of the BIR. So when a policeman claims that he is a person in authority, he is absolutely and legally wrong because he is just an agent of the persons in authority. In essence, therefore, any person in the government service is a public officer as defined, but the important thing is that he is not necessarily a person in authority or an agent thereof. Original concept of teachers as person in authority. It is originally conceived that law did not consider teachers a person in authority. It was held in People versus Mendoza, 59 Phil 163 that when a high school student slapped his teacher on the cheek while she was engaged in the performance of her duties As a teacher, the crime committed was only a light felony. This offense is punishable by the imprisonment of not more than 30 days instead of assault. Upon a person in authority, punishable up to 6 years of prison correctional. What happened then was that when the person attacked or slapped or baxed was the teacher and the attacker was the student or pupil. The only aggravating circumstance was that the act was committed with grave insult or in utter disregard for the respect which may due the teacher on account of his rank. This is contained in U.S. versus Kabiling. By that time, there was no mantle of protection accorded to teachers. From then on, there were several instances of assault and attacks against teachers, instructors, professors, and other public and private officials of schools. With the passage of Commonwealth Act number 578 on June 8, 1940, which amended Article 152 of the RPC, this picture completely changed. With that act, teachers, professors, and the persons charged with supervision and of educational institutions were raised to the rank of the persons in authority. The intent and spirit behind the amendment are very obvious. They are inherently rooted in the very person of the teacher, who is not merely an intellectual referee in the intellectual plea field and in the market of ideas, but a person of dignity and respect. When a teacher is not deemed a person in authority, there are instances when the teacher, even while inside the school premises, is not covered by the phrase person in authority. When the teacher goes out of the classroom to talk to a person on matters not related to the school or his duties, assault upon a person in authority, nevertheless, does not consist merely in attacking or laying hands on the persons in authority. It also extends to serious resistance. This means that there is active resistance or serious intimidation on the part of attacker. Teachers under security of tenure some legal basis. The praise security of tenure is a constitution guarantee. The 1987 Philippine Constitution, Article 9B, the Civil Service Commission, Section 2, Section 3 states, no officer or employee of the civil service shall be removed or suspended except for cause provided by law. Subsection 6 also provides temporary employees of the government shall be given such protection as may be provided by law. The essence of security of tenure. Professor Vicente Cinco, in his book Philippine Political Law, has stated nothing can be more demoralizing to a group of civil servants than the fear that they might be removed from their post anytime at the pleasure of their superiors. Thus, it is essentially true that a demoralized force is an efficient force. Security of tenure is a conditio sine qua non for obtaining efficiency and effectiveness in the civil service. Security of tenure does not only mean that the employee is protected against illegal dismissal, it is also guarantees the employees against unwarranted transfers made without their consent. So as closing statement, teachers' authority is very important because teachers manifest high moral values, inculcate or share learning for the students to discover their special abilities, their special skills, especially in this time of generation. Students need to discipline, and the vital part of it is the teacher's authority. So that's all for my report. Thank you for watching and listening. Once again, good afternoon.